In this lecture, I want to talk about originalism. And there are practical and theoretical justifications for originalism. A practical justification for originalism would be that it makes the most sense. As Professor Robertson talked about in another lecture, if we were to contract with each other, you and I, to do something, and then there was a question about whether that something was done correctly or per the terms of the contract, a judge who would resolve that issue would go and look at the original understanding or meaning, first the plain language, the plain text of our contract, and then determine what our intentions were. And that was the way that we would resolve a problem with a contract. So there's a practical appeal to originalism. There's also a theoretical appeal for originalism. I'm not an originalist, but I will make a practical appeal or a theoretical appeal for it. Again, as Professor Robertson has led the way on this in earlier lectures, we have an idea, a theoretical debate that constitutional scholars like to get into. And it's a debate around what we call the counter-majoritarian difficulty. This was a term coined by a former law clerk to the Supreme Court and then a law professor named Alexander Bickel. And during his clerkship at the Supreme Court, the court decided Brown versus Board of Education. And he was troubled with the fact that he agreed with the outcome, but could not come to terms with the way that the case was decided. And many people still feel that way. They agree, they know there's something right about the outcome of that case. They have a problem with how the Constitution was used or interpreted in deciding that case. And Bickel proposed, and we are still debating this in law schools, political science classrooms, this counter-majoritarian difficulty. And what he meant by this, simply this. Judges are unelected. They're appointed by presidents, right, and then confirmed by the Senate, but they're unelected. They're very insulated from the democratic process. Think about it. In our other lecture on the Electoral College, do we actually vote for the president? No, we do not. We vote for a slate of electors who then decide if our vote was the right one. Before 1913, did we vote for senators? No, they were appointed by our state legislatures. So judges are the most removed from the democratic or the majoritarian processes. Plus, they're there for life. So there's this difficulty in accepting what they think the Constitution means, right? Accepting that as legitimate. If we elect someone to Congress, to the House, or right now with direct election of senators, and they say they think the Constitution means X, it's probably what a majority of those who voted for him also think the Constitution means. So this ultimately becomes a problem, especially with life tenure. We have periods where the average belief of the average justice is very different than the average belief of a majority of Americans at a particular point in time. So this is the problem Bickel asks scholars to solve, and I think it's very important for you to understand this concept as well. How do we deal with this counter-majoritarian difficulty? How can judges act then when interpreting the Constitution in ways that are not necessarily majoritarian, but don't delegitimize the office because they are counter or non-majoritarian? Well, Bickel's solution was what he called the passive virtues. He said courts should often be passive. They should look for every reason not to decide a case. In other words, to leave it up to democratic majorities. The vast amount of cases that the court hears are challenges to laws passed by state legislatures, which are democratic majorities, or the Congress, which is a democratic majority. So they should try as hard as possible to be passive in the process. But another way that judges could maintain the legitimacy of the office is by originalism, by interpreting language as it was supposedly originally meant to be understood. And one way to understand, without giving a formal definition of originalism, because there's many of them, some say we need to have original meaning, which is what Professor Robertson was describing in a previous lecture on judicial review. And some would say original understanding, and the difference between that would be what the draftsman, for example, of a particular clause thought, or what that word and that clause meant at the time, or there's original understanding. What was the general understanding of this clause at the time it was passed? Now that potentially solves the counter-majoritarian difficulty, in a sense, the originalists would argue. But the best way, I think, to understand originalism is to give you an example of a case. And a very good case, very straightforward case that uses an originalist interpretive slant is Marsh versus Chambers in 1983. And this was a challenge brought against the Nebraska state legislature for opening up their sessions with a prayer. And the challenge was, the argument was, that this is unconstitutional because it violates the Establishment Clause of the First Amendment. Right? Establishment Clause forbids Congress from establishing a religion incorporated against the states. We remember incorporation from another lecture. So the argument was that by having a prayer at the opening of the Nebraska state legislature, this de facto established a religion in Nebraska. Well, the court said no, and very straightforwardly said, well, you know, the very first Congress opened its session with a prayer. So if that's how they understood it originally, and that very first Congress was also the Congress that passed the Bill of Rights, which included the Establishment Clause, how could this be unconstitutional? If the very men who wrote that language did not think that a prayer established a religion, if they didn't think that was the case, then how could that be the case? They're not crazy. I doubt this case cites Dred Scott versus Sanford. I haven't looked at the footnotes of Marsh versus Chambers in a long time, but that was exactly the kind of argument that Chief Justice Roger Taney used in the infamous Dred Scott case. He used originalism to argue not only that the Missouri Compromise was unconstitutional, but that African Americans could never become citizens. How, for example, could you have been a founder and at one time created the 3/5 Clause, or the Fugitive Slave Clause, or the prohibition against the slave trade until 1808, and at the same time had a conception in your head that African Americans were citizens? It just wouldn't make any sense. So, what are the pros and cons of originalism? And this might also help you understand how this mode of interpretation works. Well, one of them is that, as I said before, it solves the counter-majoritarian problem. Even though justices at one particular time might be off a little bit from what the majority at that particular time wishes, it at least can make an appeal to a distant or a past majority. In fact, that ultimate majority which wrote and ratified the Constitution. That, in a way, would solve the counter-majoritarian difficulty, so some would argue. Another pro would be that it fills in or it decreases ambiguity. What do I mean by that? Well, there are very few what we call self-executing clauses in the Constitution. Thank goodness there are a lot of clauses that scream out for interpretation, otherwise Professor Robertson and I wouldn't have a job. There are only a few clauses that self-execute, like qualifications for office. Unless you're 35, you're not going to be president. There's no room for interpretation there. Right? There's no way to say, well, 35 really meant 30, or I think 35 means 36. 35 means 35. But the interesting clauses, right? What are our privileges or immunities? What is due process of law? What is commerce? These scream out for interpretation. Because of the counter-majoritarian difficulty, though, because judges are unelected, we know we have to fill in the meaning there. We absolutely have to. Whose meaning then is more legitimate from a democratic point of view? An unelected justice who's not only unelected on the front end, but stays in the office until he or she dies or chooses to step down. So there's no way to recall them. Like we can recall it, we can vote out the guys in Congress. There's no way to do that. If we're going to have to determine what your privileges are or your immunities are as a citizen, whose answer to that question is more legitimate? Well, originalism would say, yes, we understand the counter-majoritarian difficulty. It's not my personal view, the justice might say, when I give meaning to the due process clause. It wouldn't be, that has no place. What I can do and what I should do is repair to original understanding or original meanings of this word. Because if I just read into it whatever I want, there's zero legitimacy there. Because I'm unelected and nobody can vote me out of office. But what are the cons? Professor Robertson had talked about this earlier, but I'm going to go over them again and add a few more. One of the cons, one of the arguments against originalism is whose original idea or whose original meaning or whose idea of original meaning do we accept? As he so deftly said, well, maybe we should repair to the state constitutional ratifying conventions. Well, which one? Virginia's? New Hampshire's? That was the pivotal one. And whose understanding should we repair to? Whose individual understanding? The entire legislature? The first day that they considered the document, for example? Take the 14th Amendment, for example. Its floor sponsor imagined that it would incorporate all of the Bill of Rights against the states, or at least the first 8. Well, if that was truly the original understanding, well, then we wouldn't have had such resistance to that as we still do today. So asking whose is difficult. Another con against originalism, in other words, judges trying to interpret the Constitution according to its original meaning or original understanding, is that judges are lawyers, right? They went to law school. They're not PhDs in history, or at least not all of them. So how do we think, for such an important job of applying an understanding of trying to understand what original meaning is, why should we trust or give legitimacy to a layman, to a layperson? Wouldn't we? They're not historians, right? They're lawyers. That leads to another con. They can pick and choose the history that they want. That's what their law clerks do. When you read an originalist opinion, it's going to look like that's exactly what history looked like. But there are alternative histories as well that the dissent usually picks up on, or vice versa. Whose do we accept? It's difficult to give legitimacy to that. So while originalism is attractive, and I would go so far as to say that all of us are originalists, when we first look at the text, I think we're all originalists. But when we really think about the text and experience the text and live with the text, I think we all realize that there has to be something more than an original understanding or original meaning. Not making an argument against originalism. Instead, what I'm doing is making an argument that it is not the only interpretive mode that's available, nor should it be. Thank you.
Freedom 101 is made possible by generous support from Woody Young and the University of Oklahoma Alumni Association. Freedom 101 is a program of the Institute for the American Constitutional Heritage at the University of Oklahoma. For more videos and podcasts, visit freedom.ou.edu.